Hi everyone, so today we're going to talk about humanitarian parole, parole in place, and the termination of parole. All three very important topics for everybody to learn about. So first, humanitarian parole. The idea is you're able to be paroled into the country. This is different than advanced parole, which we talked about in a different session, where you have status in the US, you're able to leave and you're able to come back in. Humanitarian parole, typically, you don't have valid documents to enter the country. Just distinguishing that from parole in place, which means you may be entered without inspection most of the time, and now you are able to be paroled in place in the United States without having to leave and be inspected, right? So this is very, very different. They're almost opposites, parole in place and humanitarian parole. Let me give you an example of humanitarian parole. Humanitarian parole actually can be done by three different agencies. USCIS can give you humanitarian parole, the consulate can give you humanitarian parole, and the CBP officer, the three immigration arms. All three can give you humanitarian parole. But most often, at least from my practice, we see it from the CBP perspective. So example would be a foreign national husband in the United States passed away, and they don't have a visa to come into the US, and they don't have a green card, they're not citizens of the US. So how can they enter the US, go to the funeral, right? You go to the CBP officer and you beg them, and after reviewing all the documents, being persuaded that this person needs to come to the US for this humanitarian reason, they are able to enter paroled in without any travel document to enter the United States, do their thing, and that they will leave the United States without getting a bond. So humanitarian parole by the CBP officer allows certain individuals to come in for a very specific time, for a very specific purpose, based on a very specific need. You're not entering illegally, you're not just crossing the border, you're getting permission to come in to do this thing, right? You don't have immigrant intent, etc. This humanitarian parole applies to all sorts of different situations. Now, business immigration lawyers, family immigration lawyers need to know this, because there are certain situations, especially in COVID, that we've seen where the consulate couldn't give a humanitarian reason fast enough, right? But they needed to come to the US to do this particular thing. If the consulate couldn't give them a visa, couldn't get an appointment, USCIS, you try to file, they couldn't give you a humanitarian parole fast enough, then CBP can. And so you can go to the border and explain your situation, and potentially they can give it, and then you're able to enter. So that is a super important way to help certain clients. Now, obviously, our client's going to fly, all around the world to go to the border and explain themselves without prior permission. It's obviously a big risk. It's difficult. It's much easier to do it at the consulate. You get an appointment, you go explain. But the thing is, there's a formal process and it takes time. Sometimes emergency happens. The funeral is the next day. Like, you just have to do what you have to do. So that is humanitarian parole. Now, parole in place is completely different, and a lot of people don't actually know how to practice parole in place, but it's super important. People who entered without inspection get married to typically a military official in the United States. I'll go through the requirements later. And then they can file parole in place and file for adjustment of status. Now, you might say, oh, if you entered without inspection, you cannot file for adjustment of status. You need to be inspected and admitted, or inspected or paroled, in order to get your green card. But parole in place basically serves that purpose. They will interview you, they will approve your parole in place application, and therefore you don't need to be like DAPCA recipients or TPS recipients or other recipients who have to get an advanced parole, leave the country, and come back in. Just by the virtue of you marrying a military official, and that being proven, then if you can get the parole in place approved, then your adjustment of status application can be approved. Now, the logistics of that, should you file one before the other, USCIS is okay with it from my experience. As long as your parole in place gets approved first, then your adjustment of status can get approved later on. You can file both simultaneously. From our practice, every field office does it a little differently. Here in California, they want a clear written statement from the applicant explaining detail when they left, when they entered, when they last entered, presumably because they want to pull the records and try to inspect as much as they can regarding how many entries you came in and out. But they want that. It's not formal in the law or in the regulations or the parole in place, but that's what the field office want to see in adjudicating parole in place applications. Let's go over a little bit about what the requirements of parole in place for people who don't usually practice it. And parole in place is a very small practice area, so it's good to know. So A popular use of parole in place is to allow adjustment of status for people who entered without inspection, spouses of military personnel and veterans, by first granting them parole in place. USCIS has now formalized the use of parole in place for the spouses, sons, and daughters, including married sons and daughters, and parents of, number one, active duty members of the U.S. Armed Forces, individuals in the selective reserve of the Ready Reserve, and individuals who previously served in these organizations, whether living or deceased, who were not dishonorably discharged. Okay, so parole in place is most often used for these military personnel. And this is a big category, right? Including living or deceased, including previously served. I mean, the U.S. military is the biggest organization in the United States. It's bigger than any Fortune 500 company combined. Not combined, but you know what I mean, right? I mean, the GDP, the expenditure of the U.S. Congress on the military is by far the greatest. And so if you enter without inspection and you married one of these individuals, basically the U.S. government is, because of your status, we're going to give you special treatment. It's just like they get really, really good mortgage interest rates, and they get really good loans and healthcare benefits. Whatever news you see about Veterans Affairs and how they don't get anything, that definitely is true for a small selection, but the general benefits that apply to everyone, the immigration benefits for veterans and for people who are in the military, being able to get somebody who violated the law, entered without inspection, and just directly get them a green card, this is huge. This is huge benefit. But the thing is, parole in place is not only for the military individuals, right? The idea of it, the Department of Homeland Security parole a person on a case-by-case basis based on two main things: urgent humanitarian reason or significant public benefit. That's extremely broad. Under those two brackets, humanitarian reason and significant public benefit, they put the military personnel. So that's formalized, but theoretically, case by case basis, as long as you can prove my client needs to be able to parole in place in the United States for urgent humanitarian reason, significant public benefit, and if it could get approved and then they marry a U.S. citizen or find a way to adjust, then they can get their green cards, right? So parole in place can technically be for a lot of different people in different circumstances. You just need to think through it and make the argument. So it's almost like a catch-all. Now, I just want to mention somebody who is filing for parole in place or granted parole in place, they can totally apply for advanced parole as well and leave the country, right? It's not like you get one type of parole and you can't get the other. You totally can get a separate advanced parole so you can leave the country to your own. Because a lot of people who are doing a parole in place, they might have been stuck here for like 5, 10, 15 years. So never having been able to leave and go see their parents or grandparents is pretty hard, right? And so they can totally apply for advanced parole just for that peace of mind. Now, lastly, I want to talk about the termination of parole, okay? When does parole end? When does advanced parole end? That's a very difficult topic. In the case law, in Kurzban, it's actually case law is split. So here's where it's split. Does it end when the authorized advanced parole, the authorized period of parole ends, right? So whatever USCIS gives you, whatever the consulate gives you, whatever the CBP officer gives you, or is it that the date ends and you are issued a notice of intent to appear before immigration court, right? So if it's the latter, which there's case law to kind of argue, you need to be issued an NTA in order for this advanced parole to be invalidated. That is good news for a lot of people. Now, what are the circumstances I'm talking about? And we're actually dealing with a case right now, and it's kind of complicated. The client got an advanced parole, but it ended, and they're out of the country. So how can they come back? Well, they try to apply for a second advanced parole. Obviously got denied because they're not in the country. Will CBP officer let them in? They already have an adjustment of status application pending, right? They got advanced parole, but they left, and they just did not come back in time. If the CBP officer looks at the advanced parole and says, your parole status eligibility to re-enter the country has ended. So I cannot give you another parole to come back in based on this advanced parole. Now your adjustment of status application is going to be denied, and your case will be over, right? That will be a huge problem. But if, hey, I haven't received an NTA yet, so therefore my advanced parole can technically continue, and a CPP officer can parole me in based on humanitarian parole, a different parole status. Maybe I'll pay the I-193 waiver of travel document to enter the country. Then maybe we can save it. So we'll see how the CBP officers adjudicate this case, but at least the case law, advanced parole or any parole status, there's a lot that pretty much clearly says when the date ends, that is when your parole status ends, which means after that you lose all your parole privileges. And parole is huge, right? It means you can live and work in the US. So if you lose your parole status, it's like losing visa, it's like losing your green card, it's like losing your ability to come back in to see your family, to work, to do everything. So that's huge. Maybe the client was like, I already filed adjustment of status, I'm already in my way to get a green card, this document expired, kind of just pay and get a new one. If USCIS, if CBP interprets this very, very strictly, sorry, now your adjustment of status application is abandoned, and now your advanced parole is no longer valid. You need to go to a consulate. You need to redo the entire application. That might be another couple years. It might trigger inadmissibility issues. All sorts of other problems can come about based on that clear termination date. So that's the biggest tricky part. But we did find a few case laws through Kurzban that says you need to be issued an NTA. And that's it for today's session. 3 main topics: humanitarian parole, parole in place, and when does your parole terminate? I hope you learned something. Thank you. See you next time.